Thank you all so much for being with us today. This is a, a joint webinar with our friends from G2 Insurance. I'm pleased to be joined by Lauren Erickson and Martin Fox Foster and Todd McCormick in the background there. If his presence is necessary, he'll materialize from the ether as well. I'm Alex Rita Baker Hostetler. And Lauren, would you like to give some introductory remarks about you and your team?
Yes, I will keep it brief. I'm Lauren Erickson. I am the nonprofit practice leader at G2. If you're not familiar with us, we are an insurance brokerage firm specializing in nonprofits. We're headquartered in San Francisco, but we have clients all over the country and a new branch in Washington, D.C. So we're thrilled to talk to you guys today about D&O because we get a lot of questions about this. A lot of times clients are confused and we want to help demystify some of the confusion for you today and talk about what's top of mind and where the focus should be for nonprofits. We'll talk about claim scenarios and just the basic understanding of D&O. So hopefully by the end of this, you'll walk away feeling like you know a little bit more.
That's fantastic. I mean, as legal counsel, we get a lot of questions from clients about D&O insurance. How much should we get? When should we get it? How do we get it? All sorts of questions. What's the difference between insurance and indemnification? What other types of insurance are there? And then of course we say, well, I'm not an insurance broker, so you'll have to talk to one of those. So pleased to have some bona fide specialists here today. So why don't we proceed? Let's dive in.
Great. So I'm going to be turning over the webinar to Martin Fox Foster, who is our Director of Coverage and Insurance. And I'll let him introduce himself because he has a pretty unique background in dealing with claims. So he is a plethora of information, and I will be kind of peppering in with some additional thoughts throughout the webinar, but let me turn it over to Martin.
Thanks, Lauren. As Lauren says, I have a bit of a unique background when it comes to insurance and particularly dealing with claims. I used to have the great pleasure of being coverage counsel for insurers and coming up with wonderful ways to deny claims on behalf of insurance companies. And so now one of the things that I do is make sure that if our clients do have a claim, that they get the coverage that they paid for, and deal with any disputes with insurers, but also help craft coverage that really responds to a client's exposures. And D&O in particular is one that is complex from a claims scenario standpoint, but also from a coverage standpoint, and particularly for nonprofits. So I'm looking forward to getting into this today. And what we're going to talk about is some of the fundamentals of D&O coverage and what that looks like for nonprofits. So we can go to the first slide. So we're going to start off talking about what exactly is directors and officers liability. And I'm going to try not to talk to the slides, but there's a lot of useful information in here. And we will share the deck after the webinar. And I think that this provides a really good basis for understanding what D&O coverage is. So D&O coverage is meant to protect both individual board members and the organization. So whilst directors and officers liability coverage is, by its name, protecting directors and officers, it also protects the organization itself for a variety of different claims. And so D&O policies, the main trigger of coverage is that there is an alleged wrongful act, and that is extremely broadly defined. So that is defined as any actual or alleged act, error, omission, misstatement, misleading statement, breach of duty, breach of trust, neglect, and breach of warranty of authority, which basically covers anything you could possibly do wrong as a director or an officer or as an organization. Because of that broad grant, at least at first glance, a directors and officers policy provides pretty broad coverage for board members and the organization.
So that's extremely helpful to understand the scope and breadth of what that wrongful act includes. I notice we haven't uttered the word fiduciary, but it's sort of looming in the background. The fiduciary obligations are what directors and officers have in common, and what the common law generally requires of them, establishing a kind of a benchmark of the way that they need to behave in order to avoid wrongful acts. So Martin, maybe, I don't know if you have a comment on fiduciary obligations and that relationship with wrongful acts.
Yeah, absolutely. So they are inextricably tied. It is that fiduciary duty which the policy is looking to respond to for board members. And then more broadly than that, any act by the organization itself, obviously carried out by directors and officers, but there is coverage for the organization itself for those acts. And one of the main things that directors and officers and board members are particularly keenly concerned with, and rightly so, is their own personal liability and those situations where they may be held personally liable. So on there's a list of the types of things that board members could be personally liable for. Obviously, the jurisdiction in which an organization is based and the nature of the organization will necessarily inform whether these things are going to be applicable to your organization. But there is the potential for personal liability for board members. What I would say is that a lot of board members are very concerned about personal liability and come from a world in which they are on either public boards or private company boards. And the personal liability associated with those versus nonprofits can be very different. In a lot of jurisdictions, you have to have done something pretty egregious to actually be found personally liable. But as is the joy of the legal system, that doesn't stop someone from suing you for it, even if you are not ultimately found personally liable. So these are the types of things that board members should look out for in terms of what they may be personally held liable for. If we can go to the next slide. So talking of suing, who can sue a nonprofit board? The obvious answer to that is literally anybody. But what are the circumstances in which nonprofit boards actually find themselves being sued? So there's a whole list there of the types of people who can bring claims against nonprofit boards. And again, it will depend on the nature of the organization and the makeup of the board and what they do as to when these particular groups of people are likely to be impacted and potentially bring suit. In terms of claim scenarios for directors and officers, and we'll expand upon this a little bit further, but the majority of claims that nonprofits find themselves on the end of are actually related to employment practices. But there are specific scenarios in which directors and officers claims are made. And these are just a couple of examples of them. So misappropriation of funds is one that sometimes comes up. So a nonprofit grant foundation receives private donations in support of their expressed mission. They then use those funds in a way that the donating organization or individual believes were not within the mission of the organization, and therefore bring suit against them for misusing those funds. And so, that's where a donation is given for a specific purpose, or the donation is given with the understanding of that organization's purpose. And ultimately, there's a feeling that those funds are used for other means. And so that's a suit where directors and officers coverage will be implicated. And then a breach of bylaws. So nonprofits which have members can often come up against D&O suits because there is an allegation that an individual was either they have elections and there is a breach of what they believe to be the bylaws of the organization, or in some scenarios, somebody is a member and they are removed as a member. And again, that member could bring a specific directors and officers suit against the organization. A couple of other areas in which we see D&O coverage particularly being hit is if the organization is involved in litigation, and they are a suer and they sue people because that is part of their mission as an organization. D&O coverage can sometimes be impacted by that litigation, particularly if they are on the receiving end of fee motions and the such like as a result of their litigation. So sometimes D&O policies can be used to respond to litigation that you yourself instigate as an organization. And then finally, we sometimes see claims that you would have never predicted against nonprofit organizations, but which impact D&O policies. So we have seen environmental organizations be the recipient of a civil RICO suit from an individual alleging that they are involved in racketeering in some way, and naming every environmental organization under the sun, claiming that they are in violation of RICO. Now, of course, that suit had no merit whatsoever and was ridiculous on its face, but the organizations still have to respond to it, and the D&O policy is there to do that. So there are sometimes things that you could never have predicted, but which pop up, and the broad grant under a D&O policy responds to that.
Martin, you bring up a good point about being sued and the D&O policy really responding in terms of your defense. And I think that is something that a lot of nonprofits or just organizations in general don't really grasp, is that the insurance policy is there to pay for your defense, even if the claim is completely baseless. And if you get sued over and over again because of the type of organization that you are, again, that policy is helping to pay for your defense.
That's great. I wanted to dwell on that point a bit as well, because Martin's quite right that anyone can sue you. Whether they will be successful, whether they'll even get a day in court is another matter. But so, the question of standing to sue a nonprofit is a very narrow one. Many courts will conclude that, in fact, if you're not a director or officer or have some stake in the organization, you don't have standing to sue it just because you don't like its mission. But that does not deter people from suing nonprofits, and they do. So that's a very helpful facet of the use of D&O insurance. Also, just as a litigation strategy, if you allege something that implicates a D&O policy, you can trigger your opponent's D&O policy, which may give them additional funds to fight the litigation, which could be an error in litigation strategy from the plaintiff's perspective, or a smart thing to do if you're in defense, to draw a fiduciary claim that triggers the policy.
Yeah, and on that specific point of potentially either being on the end of a suit that is cleverly worded to avoid triggering your coverage. Sometimes as an organization, you want to be in a position of using that policy to defend you. Whilst the plaintiff's attorney sometimes thinks they're extremely clever and have found a way to circumvent your policy, and your insurer may conclude the same, it's not always a given that that is correct. And so one of the takeaways from this presentation is you should always lean upon your broker to look at claims, determine whether the coverage can be triggered, do that if you want to trigger the coverage, and look at the policy and the claim in full and advocate on your behalf to get coverage where it can be triggered.
So is that right, Lauren? Is the broker your friend?
The broker is your friend. Your broker works for you as the organization. They do not work for the insurance company. So you and your broker should be in the trust tree. You guys share your deepest thoughts and concerns, and then let you guys decide together what you think should be tendered to the insurance company or what should be handled internally, and understand the policy together. So yes, broker should be your friend, not someone you fear.
Absolutely. If we can go to the next slide. So this is just talking about who is, or more accurately, should be covered on a D&O insurance policy. And it cannot be stated enough that every policy is different and every policy has its own nuances. There is not standardized D&O coverage. So every policy is written slightly differently. The terms are slightly different. So what we're talking about here is kind of the broad basis of what policies look like. But every insurance policy is different. They are endorsed to change the base policy. Every policy is usually hundreds of pages of, we're giving you this coverage, no, we're taking it back, now we're giving it to you a little bit more. And so again, leaning on your broker to explain where exactly coverage lies is very important. But who should be covered on a D&O policy is the organization itself. And for organizations that have multiple entities, so some nonprofits are both a C3, a C4, they then have PAC entities, or there's some other version of nonprofit entity, and they have affiliated organizations. It's very important to make sure that all of those entities are insured. Or if the decision is not to insure them, that you have done that with your eyes wide open, as opposed to they're just not being coverage because you haven't ensured that all of those organizations are being covered. In addition, anybody who is or has been a director, an officer, a member of an advisory board, a committee, a subcommittee, anybody who has done any of those roles should be covered under the policy. And policy should extend to interns, to volunteers, and the such like in their capacity of working for the organization in making decisions that could result in a suit. So again, this should be broadly worded. Anybody who is a part of the board or a committee should be insured under the policy. What I would say is that particularly extending coverage to subcommittees and the such like is not necessarily standard, but carriers should be able to do it and should be able to do it at no additional cost. So you should make sure that your policy is broadly worded in those terms.
Very good. There's a question from the audience dwelling a bit more on the broker-client relationship and talking about the question of commission versus flat fee structure. Let's see, is there a distinction to be drawn there?
I can talk to that real quickly. So brokers are paid in a couple different ways. Typically, commission is how they're paid by the insurance company. Typically, it's 10 to 15% of the policy premiums, although that can vary. If you're on the larger side of a nonprofit organization where those commissions might equal, say, $100,000 or more, you could go on a flat fee where then the broker does not take commission and your premiums would be net of commission, or you could do a combination of the two. I think the key is just transparency. But in terms of just the fact that the broker is making commission from the insurance company, it should not, and it does not, unless you have an unethical broker, which is a whole nother problem, which that would be pretty rare, is that it doesn't matter. I mean, all insurance companies pay around the same commission, and we would never place a client with a certain insurance company because they pay more on the back end or something. That doesn't even factor into our decisions, and it shouldn't. And if you feel like your broker is doing that, you need to find a new broker.
Excellent. Thank you. Another very interesting question about who's covered under the policy. This question is, is the executive director an officer or not under the bylaws, and does it make a difference? The word executive director suggests that the person is a director on the board of directors charged with oversight responsibilities, and yet the executive part of it suggests that they are an officer charged with managerial responsibilities. We certainly worry about that a lot in governance, and want to make sure that oversight does oversight and management does management, and that the two duties are adequately distinguished, lest there be confusion. But does it make a difference for insurance?
So from an insurance perspective, executive directors, whether they're called an officer in the bylaws is not determinative for the policy's purposes. Some nonprofit policies specifically state that an executive director is considered an officer, regardless of what the bylaws state. Some policies will state chief executive officer or functional equivalent. So for insurance purposes, an executive director is almost certainly considered an officer of the organization. There may be particular specific circumstances, as always, in which they wouldn't be considered an officer, but for most organizations, they are essentially considered the functional equivalent of a chief executive, and therefore treated that way under an insurance policy.
Thank you.
If we can go to the next slide. So a question we sometimes get from nonprofit clients is, why do I need another policy? Isn't coverage included in my general liability? To which the answer is no. So general liability is supposed to pay for things like bodily injury, property damage, personal and advertising injury that is done by the organization. So it's those types of claims. If somebody slips and falls, if they're damaged in a demonstration that you organized, those kinds of things would be covered by a general liability policy. And then a directors and officers policy is there to protect the nonprofit and its directors and officers for decisions that the organization makes or errors and omissions made by those directors and officers. And again, there's a listing there of the types of things that would trigger coverage under a D&O or management liability policy.
So just in terms of lingo, you can sound more in the know if you call it a GL policy, right? Usually I make sure to take acronyms and spell them out. Here I'm going to take the spelled out general liability and give you the acronym, because the first time I heard it, I was like, what is GL? Is that a word?
Yes, you will definitely sound like you're and intimidate your broker if you refer to it as GL, because they'll think that you know everything about insurance. Let's go to the next slide.
Actually, Martin, we've got two other questions in the chat that I think would be relevant to just run by real quick. The first one is actually for the slide previous to this, which is the nature of the coverage for directors and officers different from that of covering employees of the organization?
No, not really. So the coverage that is provided to directors and officers or employees for decisions made is essentially exactly the same. The only difference, obviously, the liability that attaches to directors and officers may be different than that for an employee who is just, making decisions on behalf of the organization.
Great. And then the next question, I love this question, is about volunteers. So if they are an all volunteer entity, no employees, do they need general liability? They do have D&O.
Right, yes. It depends. Probably. So if you are out in the world and engaging with third parties in any way, shape or form that could lead to bodily injury, property damage, or personal and advertising injury, then you need a general liability policy, and directors and officers is not sufficient. There are circumstances in which a volunteer organization is only granting money to third parties. It does not have organized in-person events. It does not have a location. These types of things that would indicate general liability is important. If you are completely remote and virtual and all you do is give money to third parties, then maybe you don't need general liability, but even still you may need it. So under most circumstances, general liability is a good idea, and general liability is an absolute fraction of the cost of a D&O policy. So even if it's something you may want to get, it probably makes sense to do so.
Thanks. And then one last question, which I can handle this, which is, does general liability insurance ever come without D&O, or are those usually together? And Martin can correct me, but usually they are always separate policies. So a lot of times you can get coverages bundled together, but D&O is not one of them. D&O can bundle other insurance coverages like employment practices and crime and fiduciary, but it does not usually bundle with general liability.
Okay, next slide. As Lauren mentioned, bundling coverage is kind of a standard thing in the insurance world, and particularly for non-profit organizations. So most non-profit insurers bundle both directors and officers, employment practices liability, and fiduciary liability together in one policy. And we'll get onto what those various parts mean in a moment. You can then sometimes also include crime coverage, cyber coverage, and workplace violence coverage into that same policy. So you could have 6 separate coverages covered under the same policy by the same insurer, and the pricing and the coverage and those elements will determine whether it makes sense to bundle or not. A lot of the time, bundling coverage together leads to cost savings, but sometimes the coverage is not as broad. So it really depends on the organization and the insurer. But for a lot of non-profit companies or organizations, we bundle a lot of coverage together. Next slide. So employment practices liability. So whilst we're concentrating on D&O, because employment practices liability is generally included in the same coverage form as directors and officers for non-profits. And because it is really the one of the main risks that non-profits face, and it can also bleed into directors and officers coverage, it's important to look at it. So employment practices covers employment-based claims and lawsuits, such as claims for discrimination, wrongful termination, sexual harassment, failure to hire or promote, and potentially ADA compliance by a third party. On that point, employment practices liability policies can respond not just to your own employees, but to claims from third parties. So if you have a independent contractor that you work with on a regular basis who claims that you have discriminated against them, or that they've been subject to sexual harassment, that employment practices liability policy should respond to third party claims as well as claims from employees. There's an example here of a claim type that we've seen, unfortunately, which is that over the course of a few months, several high-performing employees and volunteers leave a non-profit. The reason that they give is a toxic work environment caused by the executive director. The board of directors then investigate, and after several unsuccessful efforts to help them, decide to replace the executive director. The executive director then sues the board and the non-profit, claiming discrimination. And employment practices liability suits have the potential to be an existential threat to non-profit organizations. And this is something that we are seeing more and more often for non-profits, is that it is in the realm of employment practices that they really get not only high value claims from well-paid executives at the non-profit, but also they can be on the receiving end of claims that strike at the very heart of the organization. If you are a progressive non-profit that has a mission and a stated set of values, and somebody brings an employment practices liability suit stating that they were subject to sexual harassment or discrimination, that obviously strikes at the very heart of the organization and its mission, and can pose an existential threat in that donors no longer want to be associated with that organization. The services that you may provide as an organization, nobody wants to be associated with you going forward, because of the claims made by either an employee or a high-ranking official at the organization.
And Martin, I think that's Lauren, did you want to jump in there?
Yeah, I was just going to say that kind of segues into, you had mentioned, Martin, on this slide about third-party claims as well. And we have a question that's somewhat related in the chat about, what about if an organization has some consultants that on the payroll, not W-2 employees, but are they covered by this policy from a D&O perspective?
Potentially. So they can be, but it's not necessarily standard that policy will respond to those individuals. And both from a D&O and employment practices liability standpoint, it's important to be clear who is covered and who isn't. And that's either as the recipient of a claim, because they are consulting to the organization and there's a claim that they are responsible for something the organization has done, or as the plaintiff bringing a claim against the organization alleging some discrimination or employment practices liability based claims. So they may be covered, but the devil's in the detail, and it's important to make sure that your coverage either extends to them because you want it to, or it doesn't because you don't want it to, and that everybody is clear as to where the coverage lies. Sometimes in consulting relationships, especially if you are paying that person, the broker's perspective is that they should be the one burdened with the cost of the risk, because you are paying them. But again, it depends on the particular circumstances as to whether that makes sense for the organization.
Martin, I thank you. That's very helpful, and an important consideration, because we're constantly classifying our workers as employees or independent contractors, usually just thinking of the tax reasons, but insurance is important too. I wanted to dwell a bit more on the existential threat that you raised, which I think is important, and increasingly so. When we talk about governance in the nonprofit space, we talk about walking your talk, having your mission animate and inform every aspect that the nonprofit does, which would include the manner in which the nonprofit defends itself from a lawsuit. And so I wonder if you can get into a little bit how a claim functions. Is the insurance carrier the one that decides how the nonprofit defends against a claim that it was engaged in sexual harassment in contravention of its mission? Or does the nonprofit get to call those shots and decide for itself whether to settle on a more favorable basis than it might otherwise?
Right. And yeah, this is something that we see on a regular basis, is the potential tension between what an insurer wants to do and what an insured or the nonprofit organization wants to do with a particular suit. And sometimes it can be both ends of the spectrum. So either the nonprofit wants to settle a claim because they realize that they've done something wrong and they want to compensate the person, or they really don't want to settle it because they believe that they have done nothing wrong. And again, it's an existential threat to the organization, and they want to seem to win.
Scorched earth.
Right, exactly. Scorched earth policy. And, there are circumstances in which, of course, there are claims made which have no basis in fact, and the organization wants to be strong about stating, we don't want to be a soft touch to claims that are made that have no basis. So in those circumstances, and we'll kind of touch on it a little bit later, the policy will dictate how much control you have. Most policies allow for you to have control, some element of control over settlement, but you will likely have to pay for that, both upfront in the premium that you pay to the insurer to give yourself additional control, but also in the event of a dispute as to whether you settle or don't, there is usually a trigger within the policy that states, well, if you don't want to settle and the insurer does, you're going to have to pay more of the claim costs associated with that. And we'll get into that a little bit later on what is affectionately known as the hammer clause. So if we can go into the D&O policy mechanics on the next slide. So I'm going to briefly kind of go over this and talk about what the mechanics of a policy are. And so D&O policies for most organizations, nonprofit and for-profit organizations, are split into what they call sides. And a side is essentially a bucket of coverage within a policy that responds to particular risks. So the main determinant between the elements of the sides is who's at risk and whether indemnification is applicable to them. So for side C organizations, for side C of a policy, organizations are the ones that that are covered by those policies. So the insured itself is the organization that is the defendant in a claim. And then side B coverage responds to both the company and the directors and officers. Where indemnification applies. So in the majority of cases, the indemnification that the organization provides to directors and officers will apply to a particular claim. Obviously, it depends on the particular indemnification agreement of an organization, but they are usually pretty broadly worded and provide indemnification under most circumstances, unless, again, you do something horrendous or the organization is not in a position to indemnify you because the company or the organization no longer has any financial assets. So in that case, the policy still responds, it just responds on a different basis and covers the director or officer personally and covers their own personal assets from being targeted. So the policy steps in those circumstances. And these separate buckets, in the majority of cases, don't matter. You get a claim, the policy comes in, it's responded to by the insurer, indemnification applies, there's no bankruptcy to the organization, there's no issues there. It's really in extreme circumstances where indemnification doesn't apply because the acts of the director and officer are so egregious that it falls outside indemnification, or the organization has gone belly up and the policy has to respond on a non-indemnification basis. And that is very in the weeds, and I've given a very brief overview of it. But if you ever want to discuss the differences between side A, side B, and side C, I would love to, because I'm a sad case. So let's move on to claims made coverage. And this is an important element of D&O policies and employment practices liability policies and other types of coverage like cyber that organizations should be aware of. So D&O policies are claims made, meaning that coverage exists only for the claims made during the time period the policy is in effect. So most policies run for 12 months and they only cover claims that are made within that policy period. And what that means is when you get a written demand or lawsuit from a third party bringing a claim against you. So whereas general liability coverage is on an occurrence basis and covers any injury that occurs during the policy period, so that somebody could sue you for a slip and fall that happened in 2018 and the 2018 policy would respond. Under a D&O policy, what you did wrong may have occurred back in 2018, but they are suing you in 2022. And so it is the 2022 policy that will respond to the claim. And it's important that you know that, so that when a claim is made, when you get something in writing demanding money from you, if you get an allegation that you have done something wrong, you place your policy on notice immediately so that you do not fall foul of the policy running and then looking to put a carrier on notice after the policy period has run. Next section on choice of counsel. So this is very important and something that nonprofits run up against on a regular basis, which is policies either do or do not give you the choice to decide who your attorney is to defend a claim. The majority of policies for nonprofits, if they are smaller organizations, will be what they term duty to defend policies, in which the insurer has absolute control over who they choose as your attorney. So they get to determine which law firm they use. They have pre-negotiated rates with those law firms. They pay them a lot less than what you are likely to be paying your attorney, and they get to choose. And the alternative is that you get choice of counsel. You get to choose who your attorney is, but again, you will have to pay the commensurate premium that is associated with that control. And even where you have choice of counsel, what your counsel charges you and what the insurer is willing to pay for that counsel may still be, there may still be a delta between them. So we had a recent claim, very high profile claim for a very high profile nonprofit, and they wanted to choose their own counsel. Their policy was actually a duty to defend policy, where they didn't have any choice of counsel, but the policy said, we will consider your choice. So it says, we'll have a talk about it. We might allow you to choose your own counsel, but they still get to set their own panel rates for who you choose. And because this is a very high profile organization and a very high profile claim, their attorneys were charging $1,000 an hour to work on the litigation. And what insurers usually pay counsel is between $300 an hour and at best $600 an hour. And so we were able to get the insurer up to a very high level above what they would usually pay, but there was still a delta between what the organization's attorneys were charging, and that was on a reduced rate, and what the insurer was willing to pay. So even where you have choice of counsel, or where the carrier will allow some deference to your choice, there will still necessarily be a difference between what counsel will charge and what the insurer will pay.
Martin, what if a board member is an attorney and is willing to work on a claim pro bono?
Yes, we do see this sometimes, is board members or an associated law firm saying that they will do things on a pro bono basis. The majority of the time, that is really not a good idea, either because there is some interest between the board member and their law firm in coming to a particular conclusion in a suit. And also, insurers just are highly unlikely to allow it to happen. Even if they are doing it for free, insurers do not want anybody who has a potential conflict involved in that litigation, and they want to have counsel that they know, or at least that is independent of decision making at the organization, to deal with a claim. I do see organizations sometimes using counsel that they know very early on in a potential issue, just as a sounding board, and they do that on a pro bono basis. That's fine, to get somebody's opinion if they're willing to give it to you for free, but as long as it's not something actionable, or anything that really requires an insurer's input, then we don't want pro bono counsel or somebody associated with the board involved in those issues.
I think that's an important thing to note, is that if you are working with pro bono counsel or reduced rates, once you file that claim and it's an accepted claim by the insurer, you have to transfer the control, unless you have choice of counsel, over to the insurance company and whatever they want to do. So you cannot continue to use your counsel once it has been tendered to the insurance company and been an accepted claim.
Yeah, and so it's a very important thing to get sorted up front with your broker. If you have a law firm that you absolutely love, knows the organization very well, and is willing to work at panel rates for an insurer, then getting that pre-agreed by the insurer is an important thing to do. But equally, one shouldn't want counsel involved in matters that are too tied to the organization. because sometimes the advice that they're willing and able to provide is not the independent advice that you need when you're dealing with litigation. So let's go on to the hammer clause. We did briefly mention this earlier, but most D&O and EPLI policies include a provision known as the hammer clause. It essentially states that if you do not want to settle a claim that an insurer really wants to, then you take some financial burden as a result of that. And what they usually state is that you can not provide your consent, and that's fine. But what the policy will say is any amount that is paid out above and beyond what the insurer would have settled for at some later date, you are responsible for. And what it may also say is that you are responsible for a percentage of any of the defense costs from that moment that you disagree with settlement. So you could be on the hook for a significant portion of both any potential settlement that is made at a later date in time that is above what the insurer wants to settle at, or if there is a judgment made against you, then you will be responsible for a percentage of that, and also for any defense costs. So usually the calculation is about, number one, whether you want to refuse to settle, but also how far into this litigation are you? What are the potential costs going to be? And what's the potential outcome? Because you're then really gambling with the organization's money as to what the outcome is going to be. And in some circumstances, it makes perfect sense not to settle. You know, the claim that is being made is existential to the organization. You want to fight it. You believe that you have good grounds to do so. And the insurer is, as insurers are, not wanting to settle under, not wanting to go to court under 99% of circumstances. So sometimes it does make sense, but there is a financial hit. And so most policies either say you're responsible for 30% of the costs, or you're responsible for 20% of the costs, or you're responsible for 10% of costs. And it really depends on the particular policy as to what that looks like. Some policies don't have a hammer clause at all and require your consent to settle anything. And in those circumstances, the insurer just has to eat the fact that you do not wish to settle. But those policies are few and far between. Next on to shared and separate limits. So as some of these policies are bundled together, some of these coverage parts are either have separate limits associated with them. So you have 2 million for D&O, 2 million for EPLI, 2 million for crime, or they are, you've got 2 million for all of those coverage parts. And what's important to look at is, do you want those risks pooled together and shared, and you get the benefit of the price being lower? Or do you want to separate those risks out to ensure that there are limits for the potential that you're dealing with multiple claims under the same policy period? And we do sometimes see policies whose limits are exhausted, and then other claims come in and they can't be paid out because there was a shared limit that was exhausted under the policy. But again, that's about picking the right limit and picking whether you share limits or not. Just briefly on fiduciary versus fiduciary liability. So directors and officers are fiduciaries, but fiduciary liability is not D&O liability. So fiduciary liability is a separate coverage which stems from employee benefit plans such as 401ks or 403bs, and the liability around decisions made related to those employee benefit plans. That coverage is extremely inexpensive, and if you have an employee benefit plan, you should 100% have fiduciary liability. And then finally, there's ERISA Fidelity, which covers theft or loss of plan assets under a fidelity bond or a crime policy. And that's a whole separate coverage completely and is required by ERISA. And again, if you have an employee benefit plan, you should have that coverage in place.
Martin, just briefly on the notion of a crime policy, does a crime policy cover both acts perpetrated by the organization and its agents, as well as crimes perpetrated against the organization, or are those separate?
No, yeah. So crime policies respond to both theft of funds by employees of the organization, and fortunately you see it on an all too regular basis. Is the CFO of an organization has been pilfering funds for years, and a crime policy would respond to that, but it also responds to if a third party is stealing from you, it responds to those types of claims as well. Yes.
And those might overlap if, for example, it hasn't been determined whether the CFO was stealing or not, right? It could be a breach of fiduciary obligations first, and then if a criminal court determines it later as a crime, then it could be a criminal.
Yeah, absolutely. And crime policies, depending on the coverage, sometimes don't require that there is a criminal court determination of a crime. They will respond if money has gone and the only logical conclusion is that somebody has stolen it, even if a criminal court has not convicted somebody of it. So crime policies can still respond even if an actual crime has not been convicted. Wage and hour claims. This again depends on the nature of the organization, but what we have seen is a proliferation of wage and hour claims, which essentially claim that the organization has not paid employees properly for time off, time worked, etc. Most organizations have pretty decent risk management around it these days to ensure that proper timekeeping is being done and that people are allowed breaks, etc. But we do still see claims like this. Under most employment practices liability policies, there is coverage for this, but it's sublimited to a smaller amount, and in some cases, sublimited purely to the defense costs. So they will provide you with $100,000 to defend these claims, but they will not pay for the money that you should have paid the employee. They'll cap out at that defense cost. And for most of these claims, unless they are extremely large, there usually is some error on the part of the employer, money has to be paid back to the employee, and so the defense cost being capped is not a major issue. But again, it depends on how historical those are and what risk management was in place to avoid those types of claims. And then umbrella limit. Another question that we get from some organizations is, well, I've got $1 million in D&O, but I've got a $10 million umbrella. Does that not go over my directors and officers coverage? And the answer is no. So in most circumstances, umbrella policies do not go over D&O policies. They only go over general liability, workers' compensation, auto policies, those types of coverages, international package policies if you have them, but they do not go over D&O. So if you need more D&O coverage, you have to buy specific D&O policies that go above your current limit. And so most insurers' D&O policies cap out about $5 million. And then you have to purchase another $5 million on top of that, or $10 million, or 15, or 20, 25, whatever it may be, depending on the organization and the risks and what you determine is an appropriate limit. Next slide. And then just finally from me on reporting requirements and what constitutes a claim. obviously the reason we buy insurance is that if we have a claim, it responds. It is important to make sure that if you have an incident, a potential issue, something you think might bubble up to become an issue at a later date, that you speak to your broker about it. Because these are claims-made coverages, what you don't want to do is have something happen, not report it to the carrier, and then have an issue over reporting, and the policy potentially not being covered. So what constitutes a claim is dependent on the specific policy. The wording that we have there is kind of standardized, but each policy is different. So it's important to look at it with your broker and understand what your policy will respond to. And then if you have a genuine claim, to report it to the carrier. As we spoke about earlier, the broker is your friend. So if you're worried about the response of an insurer to making a claim, or worried about, well, if I put in a claim or even a notice of a potential claim, what's going to happen to my premium, et cetera, speak through that with your broker, because the majority of the time, it makes sense to place the carrier on notice so that you don't fall foul of the reporting requirements under a policy. There may be some price consequence, but if it comes to nothing and there is no claim, it's the broker's job to make sure that the insurer understands that there was no cost associated with that claim. You did the right thing as an insured to report it. And that's what makes you a good insured, and explain that to the insurer. And so if your broker is not doing that, then they're not doing their job. So it's important that you understand that claims being made is not the end of the world, and that the most important thing is that you preserve coverage because you don't want to be without it. And then final slide. So this is just on indemnification, and Alex, maybe you can speak to it.
Yes, sure. So I think we're just about at the end of time here. So I just wanted to wrap up with a slight distinction between indemnification, which is the use of the assets of the organization to pay a claim, versus insurance. Your bylaws can construct and establish a policy for which types of actions are eligible for indemnification and which are not. And those might supplement or interact with your D&O insurance coverage. And so it's important to take a look at that indemnification provision in your bylaws, or if you have another policy, and read it together with your D&O coverage to make sure that you're covered. Great. Well, that's all I have. This has been extremely helpful, very useful information. Given us a lot to think about. Any final words from you, Lauren and Martin?
No, really appreciate everyone sticking on a couple minutes past the hour. If you have any other questions or want to run through scenarios, our contact information is here. Please don't hesitate to reach out, and we appreciate it. So thanks so much.